Bismillahirrahmanirrahim. Assalamualaikum semua. Sejak belakang ni banyak kes-kes Islamic banking ni telah diperkatakan di media sosial dan di mana-mana. Jadi saya rasa bertuah pada hari ini kerana saya dapat menjumpa seorang pakar dan dapat menemu seorang pakar mengenai Islamic banking di Malaysia, dan dia juga seorang pakar di Malaysia dan di luar Malaysia. Okey, saya akan baca secara ringkas CV Prof di mana dalam bahasa Inggeris. Profesor Dr. Mahmud Sanusi was working with International Center for Education in Islamic Finance, INSIF. Prior to this, he was attached to the Kuliah of Laws, International Islamic Institute, IIUM, from 1984 until 2008, and others as well. Professor Dr. Mahmud Sanusi has published his works in various reputable academic journals, including International Journal of Financial Services, Arab Law Quarterly, Journal of Money Laundering Control, Cambridge University, IIUM Law Journal, Journal of Regional Islamic Council of Southeast Asia and Pacific, and Chapter in Innovation, Regulation, and Legal Perspective and Islamic Finance book by Edward Elgar Publication. He has also presented several papers concerning different issues on Islamic banking and finance at various seminars and conferences, both national and international. He is currently a Syariah expert in Islamic banking and financial cases. He handled a few cases starting 2015 until today. Professor, we asked for a meeting with you to have a session with you because there are widespread problems in Malaysia and Southeast Asia. 99.9% of Islamic banking customers who had the facilities through Islamic banking, many of them lost their properties and assets. This is happening long time, more than 30 years in Malaysia, because the Islamic banking customer who involved in cases against them dissatisfied and remain and uneasy and doubt with the court's judgment and the court's siding completely Islamic banking without concern of the customer's interest. Okay, Prof, can you start it?
Okay, Bismillahirrahmanirrahim. And salatu wassalam ala Sayyidina Muhammadin wa ala alihi wa sahbihi wa sallam. The questions which you presented to me is that why until now the bank customer when they go to the court, when they have any problem with Islamic banking, they lose their assets and also their property, you understand? And the most important, they are not satisfied with the court judgment, right? And we want to know why the judgment of the court until now is most of it is treating all the Islamic banking as lending and borrowing. First, this is one thing. The second, we have to do some research about the legal documentation which it is being given from the Islamic bank to the customer. Okay? Is this legal documentation is really following the fiqh mu'amalat rule and principle? I'm mention again, is fiqh mu'amalat rule and principle, or all this legal documentation, even though they use Arabic terms like ijara and al-baya, okay, but actually when we look into the legal documentation, meaning that when we look into the terms and the condition which it is being inserted in the legal documentation, anyone who have doing a research will find out is that all this legal documentation is mimicking loan and credit-based conventional bank. Is only the difference is they are changing the terms. For example, from hire purchase, they're saying ijara. That's all. Okay? But the term and the conditions is like hire purchase based on credit. Also, in sale contract, they try to manipulate the terms and the condition in the contract of sale. Okay, later we will clarify all these things. You understand? One by one. Okay, they manipulate it and they draft the legal documentation in the way is that exactly mimicking a credit-based loan in conventional, right? Okay, why? Because one of the policy of Bank Negara is that all Islamic banking cases have to go under the jurisdictions of civil law. And when they go under the jurisdiction of civil law, automatically the judge, he have no experience in fiqh mu'amalat, right? And in what you call Islamic principle, the Sharia principle, okay, and legal maxim. So he will treat this contract, even though they write it sale or ijara, is treated exactly as a conventional contract because the terms and the condition. And this is why the customer who involved in these cases, first they lose the asset, right, for the bank, okay, when they have a default, right. The second thing is that they are not satisfied with the judgment of the court. Okay, even though for many cases, as my experience is that the court itself sent the expert report to the SAC, but SAC actually they don't reply according to the terms and the condition in the legal documentation which it is being signed by the bank customer. Okay, so this is actually a lot of issue here. If we try to clarify, then this will take few sessions to clarify to the people, right? Okay, one by one. Okay, but the most important is that now is that we try to protect the interests of the customer who signed this legal documentation, which is given by the Islamic banking, and which the customer, they don't know how far they've been trapped in the terms and the conditions of this legal what you call legal contract and legal documentation. Another issue is that which with my experience, and I ask the bank customer, when they go to the bank before they sign the agreement, okay, some of the customer, or now we teach them, please, I want from the bank to give me the draft of the legal documentation before I sign, so that I can take this agreement, asking the expert people, you follow me or not, to clarify how far I can protect my right, and also what is my obligation toward when I sign the contract. But the problem is that all the Islamic bank in Malaysia, they refuse, the officer refused to give you the legal document, the draft of the legal documentation. They will tell you, no, you sign first, then after that you can take the what we call the legal documentation contract. You understand? And this is actually working against the interests of the customer, because the customer, he want to know what, when he is involved in the agreement, he want to know his right and his obligation, right? Okay. So, but the bank, all the bank in Malaysia, they refuse to give the draft. They told him, you sign first. Once he signed, he's already been trapped already in the terms and the condition of the contract which is being given by the Islamic banking.
So you mean, Prof, your coming session is to educate people and make them aware about legal right and obligation after they sign the contract?
Yes, brother. This is exactly what I mean. This is not as a, what we call attacking someone or criticize someone, but the motive of this session is to educate the bank customer, Islamic bank customer, and make them aware before they lose their property and the asset.